situation, we can go ahead and convene the meeting at 6:03 p.m. And the first order of business is the roll call. So if each of you would state your name and say that you're present.
Michael Rhodes, present.
David Bench, present.
Michael Hall, present.
Hello?
Oh, Michael Rhodes, present.
Oh, okay, I didn't hear you. All right, Amy Rodnick, present. So we've got 5 members, that is a quorum, and then we've got
Tony
Jordan,
Stein.
who
I
is
didn't.
present.
Tony Stein present.
And
And
Jordan?
Jordan's got
I'm sorry?
I'm
Jordan,
present and
you're
online.
here
Yeah.
via Zoom. Okay, so that gives us 6 members. All right, and the first order of business is public comment. If we have any citizens who wish to address the commission regarding items that are not on the agenda, limited to 3 minutes. I don't see anybody. Do we have anybody on Zoom? No. Okay, all right. Well, then let's go on to the consent agenda. And we have the minutes for August 31st, 2021 and October 6th, 2021. And hopefully everybody's had a chance to review those minutes. And if you had, then I'll entertain a motion and a second to approve the consent agenda. Do we have a motion?
I'll motion to approve.
All right, do we have a second?
I'll second. This is Jordan.
I'm sorry, Jordan second?
Yes.
Okay, all right. So Michael made the motion, second by Jordan, and is there any further discussion on this? If not, all in favor of the consent agenda, please say aye.
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 All right, thank you. Now we move on to the regular agenda, and our first order of business is to welcome Dave Bench to the Planning Commission. So, welcome, Dave.
Welcome.
Pleased to be here.
Okay. Next item of business is discussion and possible action to elect the chair of P&Z. Is there anybody who would like to be the chair?
Newest member, chair.
That is so cruel.
I think I gotta find the chair first, so.
We'll get you a bench.
We don't have any volunteers at all? Is there somebody who maybe would like to do it sometime soon? Jordan, you remember what I said when I came on here, that I would do this only if I didn't have to be chair again.
Do remember that, and yet we just passed a whole bunch of minutes that show you as acting chair, so I'm
No,
I'm just saying.
the operative word is acting.
we're not making you chair, Amy, we're making you acting chair. Just for the next few years.
I guess I am acting chair for one more meeting here. I'm going to have to figure out what's a suitable revenge. Okay, so I am, I guess, acting chair. I would love it if one of you would love to be chair, you know. Think about it. If not, you know, you will be visited by a specter late in the night sometime. You won't know when. The next item is public hearing, discussion, and possible action on an ordinance to update Chapter 107, Article 5, Division 3, Board of Adjustment of the City of Rollingwood Code of Ordinances to meet state requirements. I guess first we can open the public hearing on this. It is 6:07 p.m. Do we have any members of the public who would like to speak on this issue? I don't see any. I'm assuming no one on Zoom. So then we will close the public hearing at 6:07 and hear from our city staff on this issue.
Do you want to start it out, or do you want me to start it out?
Charlie, let me start it out.
Okay. So this was before City Council, and City Council asked it to go to the Planning and Zoning Commission with changes to be presented consistent with state law for your review and consideration. So did everybody get a copy of the red line changes?
I looked at it online
Okay.
before I came.
Does everybody have a copy with them now?
Yes.
Yes.
We've got a copy of
I think we have, a lot of us have laptops, and then we also have.
Yeah, sure.
copies,
Whether physically or electronically, doesn't matter.
Right. Charlie, do you want to kind of give us a summary
Yeah,
of
I thought what I'd do is
what
I'd just-
these mean?
Yeah, I thought I'd just go through all the changes so that y'all fully understood why each change is being proposed.
All right, that sounds good.
All right? And so, if we look at on page 1, line 13, line 12 and 13, you'll see that we've added the phrase rather, at least 75% of the members. Previously, this read that all cases heard by the board will always be heard by 75% of the members. That has a little different context, and it's also not consistent with the way the statute reads. The statute actually reads that it will always be heard by at least 75%. So we made that change for consistency and clarification.
All right, and then it looks like the next is line
Well,
23.
line 23, I added this language upon written charges being presented to the member. I assume that was the intent, but I wanted to make clear in the ordinance that these written charges are required to be presented to the member who is being not targeted necessarily, but who is being potentially removed from the board. And that's for mostly due process concerns.
All right.
No changes on the second page, and I guess one thing I didn't do was put numbers at the bottom of this page. I apologize for that.
Well, we've got
Our
the,
copy of page 16 is.
yeah, we can just go by the upper left numbering.
Yeah, and we didn't do that's right, we didn't do the numbers, we didn't redo the numbers on each page, so these are continuous numbers throughout. So if we look at line 58, this change, you'll see this change throughout the ordinance. The ordinance previously referenced division. So if you look where it starts on line 56, subsection D, it says the concurrent vote of 4 members of the board shall be necessary to reverse any order, requirement, decision, or determination of the building official, or to decide in favor of the applicant on any matter upon which the board is required to pass under this division. Well, the division is the section, for lack of a better term, where the Board of Adjustment process is at. So it's really the chapter, because it's the chapter that spells out anything that they need to be done. So everywhere where it says division, we've changed that word to be chapter to be consistent with what is actually being intended.
It looks like a lot of what you're doing here is more, more form than substance.
Some of it is. There may be some changes in here that y'all might consider to be more substantive nature, and we'll go over those.
Okay, and you can
But at least up to this
call
point, that's a true
that
statement.
out when you come to
I
it.
most certainly will.
All right.
The next section, the next line, 60, section 107.4-90. Some of some of these changes are also, like you said, form-based, because it was a little difficult to follow the code as it was written. Things were in weird places, and so we moved some things around so that it's consistent with what we're trying to accomplish. This is one of those times. So section 107 used to read appeals based on error, but we have changed this to be very specific to the powers of the board. All right, so this section is going to list out all the powers of the board. And you can see on 61 we have changed that to read, the board shall, pursuant to the provisions provided for herein, have the power to, and then we left the first part, which is hear and decide and appeal, etc. We added number 2, hear and decide special exceptions as authorized in this chapter, and special exceptions are authorized in the chapter. Authorize a variance to the regulations as provided for in this chapter, and variances are authorized under the chapter. And then determine in cases of uncertainty the classification of any use not specifically named in the chapter. Now, that was previously placed in section 107-491, so we just moved it from section 107.491 to this section, all right? Section 107-491, this is the special exceptions section of the ordinance that talks about the granting of special exceptions. So this first line here on page 72 is where I'm making a substantive change, and I'll explain to the reason why. Oh, no, this is not a substantive change. We moved it. So it says, when in its judgment the public convenience and welfare will not be substantially or permanently injured, the board may, in a specific case, grant the following special exceptions. That first part, I have simply moved it to a different section, all right, so that all of the findings are in one place, because this was actually a finding that needed to be made, and then there were findings in subsection C also. So I just moved this to subsection C. So now it reads, the board may, in a specific case, where the board makes the findings required under subsection C herein, grant the following special exceptions, etc.
Did you strike the public notice and hearing requirement because it's not required? Or does that show
No,
up
because
later?
we have another section later that deals with
Okay.
the notice and hearing requirements. So that was repetitive. Good question. I'm sorry I missed that. So, before we get to subsection C, you can see there's a change made on line 88, and this is a substantive change. This would have permitted a public utility, this would have permitted the Board of Adjustments to grant a special exception to allow a public utility or public service use or structure in any district. That's not authorized under the law. In order to allow a structure to be placed in another district, the city council has to go through the legislative process associated with changing the zoning district's regulations. So there's case law directly on point that provides that a Board of Adjustment does not have the legislative power to authorize a use in a district where that use is not authorized. So we struck that. So subsection C, this is where we moved that the section that was originally in section 1. So now subsection C reads, prior to granting a special exception, the board shall make a finding that it is empowered under this chapter to grant the special exception. Then the new language which is moved, that the public convenience and welfare will not be substantially or permanently injured in the granting of the special exception, and that the grant of the special exception will not adversely affect the public health, convenience, safety, or welfare. So those are the findings that are going to be required. And those were left the same. I just moved and slightly reworded it from section A. Section 103 I just revised for clarity. Previously, beginning on that second sentence, it said failure to begin or complete or both such action within the time limits set shall void the special exception. I felt that was a bit wordy and cumbersome, so I revised it to read failure to comply with the time limit set by the board shall void the special exception, which is more concise and, in my opinion, more clear with respect to what happens if you don't meet the time limits. And then we deleted F because F was really a power of the board, and so if you remember correctly, we moved that from where it is now up to the previous section where the powers of the board are located. So this hasn't been deleted; it's just been moved to another section. And also, determining in the case of uncertainty the classification of a use not specifically named in a division would not be that would not be a special exception. That's actually just a power that the board has. All right. Section 107-492, there's quite a few changes to this section. Some of it was changed for clarity. As a matter of fact, the first few changes there in lines 110 through 114, all those are made for purposes of clarity. Basically inserted language that the board has to find the findings that are in there 1, will not be contrary to the public interest. 2, where owing to special conditions, literal enforcement of the provisions of this chapter will result in unnecessary hardship, and the spirit of the chapter will be observed and substantial justice done. Those changes I made in there are mostly for clarity purposes. I have deleted 1 and 2 in their entirety. The reason for that is because it says includes the following. It's unnecessary to lay out the specific provisions, because if someone requests a variance, then the board can consider that variance. And second, there is some inconsistency with state law with these provisions. For example, so let me back up a little bit. Chapter 211 of the Texas Local Government Code is what deals with zoning regulations. And section 211.009 specifically lays out the authority of a board of adjustment. And because two legal concepts, the first is that a general law city only has that power granted to it by the Texas legislature. It cannot have any power or authority to do anything that's not granted to it. And second, because a board of adjustment is a statutorily created quasi-judicial body, it only has the power that's granted to it by the Texas legislature. And the cases interpreting these sections of the statute have basically say that a zoning board of adjustment may only do what it's authorized to do in the statute, and must do it consistent with the provisions in the statute in any ordinance that's been adopted by the city, so long as that ordinance is consistent with the statute. So a city can't adopt a different standard, it can't adopt different reasons for granting variance and such. And so the authority of the board specifically provided for in the statute in section 211.009 says that a board may authorize in specific cases a variance from the terms of a zoning ordinance if the variance is not contrary to the public interest, and due to special conditions, a literal enforcement of the ordinance would result in unnecessary hardship, and so that the spirit of the ordinance is observed and substantial justice is done. That's what the Texas legislature has told us is the standard for granting a variance. If you look on line 115 and 116, it says permit a variance in yard requirements where there are unusual and practical difficulties. That language is not found anywhere in the statute. Unnecessary hardship is found, but not unusual and practical difficulties. And so we struck this because that language is not consistent with the statute. And an individual can still come get a variance to the yard requirements, but they have to prove that that the variance is not contrary to the public interest, that there are special conditions of which a literal enforcement of the ordinance would result in unnecessary hardship, and that the spirit of the ordinance observed and substantial justice is done. Practical difficulties does not play into the analysis.
Is there really any difference between unusual and practical difficulties and unnecessary hardships? I mean, it really could be construed as almost the same thing.
It may or may not.
Yeah.
I guess it depends on the zoning board of adjustment. But the issue is that the statute uses very specific words,
Right.
and we need to use the same words that the statute does, because the worst case scenario is that we grant a variance of this type based on a practical difficulty. A neighbor or a taxpayer brings a lawsuit challenging the decision because there was not a finding of undue hardship, but only a finding of practical difficulties, and the court says practical difficulties is different than undue hardship, a lesser standard, and therefore it's void. So we should just use the same words that the courts use, that the statute use, because those are the words that the courts have interpreted for purposes of granting a variance. I've revised section B to make clear that in concert with the findings required in subsection A, which is the specific language from the statute, right? Division A says, will not be contrary to the public interest, where owing to special conditions, literal enforcement of the provisions of the chapter will result in unnecessary hardship. The spirit of the chapter will be observed and substantial justice is done. That's right out of the statute. So B now says, prior to granting a variance in a zoning district, other than a residential district, the board must find, in concert with those findings, that the variance is the minimum variance necessary to alleviate the unnecessary hardship. I believe that that language is consistent with the statutory language. I can defend that.
I mean, the intention is clearly to be a little more limiting in a commercial district.
Yes, that's
And-
clearly, they're saying there may be multiple variance options here, but the Board of Adjustment should grant the minimum variance necessary to avoid the hardship.
And we have the right to do that.
I think that this language is consistent with the statute, yes.
Is it, and it's okay to hold different districts to different standards?
Yes, it is. Mhm.
Okay.
Yeah. Especially differences between a commercial and residential district. Just the next line, 129, is just another change from division to chapter. I have struck the previous section 3 that states literal interpretation of the requirements of the division would deprive the applicants of rights commonly enjoyed by owners of other properties in the same district under the terms of the division. This is just my legal opinion, but I don't believe that this is consistent with the statute. This is actually invoking a different standard than what the courts have interpreted those things to mean. The remainder of these is actually language out of cases. So I'm very comfortable with these because courts in interpreting what an unnecessary hardship is, all of those things, have actually used these as reasons, all right? Special conditions with respect to the variance sought are not the result of an action of the applicant. I revised that a little bit to clean it up, but that's consistent with the case law. Granting the variance will not confer on the applicant any special privilege that is denied by this chapter to other land, building, or structures in the same district. This is a bit problematic for me, and
Is
you
it
might want to
worth-
discuss it.
Can we go back to 3? Is it worth or defensible to include with the applicant any like successor owners? You could see where somebody set something up, sold it, and then said, well, this wasn't of my creation.
I think so. Here's something interesting. The denial, I am rarely that concerned with the denial of a request for a variance. And that's because the board is not mandated to grant a variance. The ordinance and the statute both make it permissive. So technically, an applicant could come in, meet all the requirements necessary under our code to be entitled to a variance, but they could still deny it. And that's okay under the law because they're not entitled to the variance. They're entitled to come ask for it, but they're not entitled to it. So they could meet all the requirements, and the Board of Adjustments could still say, you know what, we're just not comfortable with this, so we're not going to grant your variance. I believe that we could. I'd have to take it a little closer to see if previous actions by previous property owners, in other words, the current applicant buys into the problem, if that is consistent with the case law. My recollection of the case law is that it's not, but I'm happy to look into it a little closer and bring back, if y'all want this to come back, or a recommendation to council.
Well, wouldn't normally, if an applicant had committed misconduct or something which caused them to have to ask for the variance, wouldn't that also flow to the next owner
Yeah.
in the sense that, you know, the next owner doesn't get a clean slate on that.
Yeah, so the cases have interpreted this provision to basically say it's to prevent somebody from doing something intentional and to try to get around the requirements of the regulations. Somebody who buys into the problem didn't do that. So they bought the property and the property is as is, but they didn't actually try to create a situation so that they can then get around the regulations of the ordinance. They may have bought into it, but they didn't actually create the situation. But
And
again,
the board can still turn it down in that.
the board could still turn it
situation,
down
too.
in that situation. They absolutely could, which was my
So it's
original
not a
point.
requirement to
Right,
pass it
exactly.
just because they.
The board could still say, yeah, well, you bought it and you knew it was a problem, so we're not comfortable granting this.
But
They
if you
could still
didn't
do
know
that.
it, if you didn't know it, wouldn't that be a hardship?
Yeah.
Well, it's up to the
That can go both
interpretation of the
ways.
board.
It's
Yeah,
up to
right?
the interpretation of the board. The
Yeah,
board has
yeah.
the full discretion of,
Right.
remember maybe not remember because you're brand new on the zoning board of adjustment, on the P&Z. The zoning board of adjustment is a quasi-judicial body. It takes evidence, it hears the facts, people are often sworn in under oath when they give testimony, and they make factual decisions with respect to whether or not hardship should be granted, special exceptions should be granted, and anybody who disagrees with that decision, either the applicant or a taxpayer or an agency of the city, the only way to appeal the decision of the zoning board of adjustment is to go to district court. And so they are a quasi-judicial body, and they have a lot of power of discretion. And I am adverse to pinning them down to very specific requirements associated with the decision making.
Yeah, it seems to me if you buy in, you shouldn't lose your right to go before the board because of something somebody did before, but it also doesn't mean you get your variance granted just because you didn't know about it.
Yeah.
Or didn't figure it out.
It could go both ways for sure.
So the next major change begins on line 144. Currently, it reads, granting the variance will not merely serve as a convenience to the applicant, but will alleviate some demonstrable and unusual hardship or difficulty so great as to warrant such variance. Again, not consistent with the language of the statute. The statute doesn't use the word unusual. The statute uses the word unnecessary. And so we've struck unusual and replaced it with the word unnecessary to be consistent with the statute. And then included the rest of that section, which is created by the literal enforcement of the provisions of the chapter. That is specifically consistent with the way the statute reads. And then, of course, we struck or difficulty so great as to warrant such variance, because difficulty so great to warrant the variance is also not part of the statutory language. Then there are some findings that our ordinance requires for a residential district. And so I've added the language in concert with the findings required in subsection A, because they have to make those findings as well. I've changed one to read it currently reads, a special individual reason makes the strict application of this division impractical. Again, not the language from the statute. So I've changed it to read, a special individual reason makes the literal enforcement of this chapter result in an unnecessary hardship. That's the standard set out by the statute.
Charlie, what row are you on right now?
I was on, that was line 150.
150. Okay, thank you.
Sorry about that.
No worries.
And then if we look at line 161, I've done the same thing. It currently reads that there are special conditions such as topography, natural obstructions, aesthetic or environmental considerations affecting the land involved, such that the strict application of the provisions of this, it says division, need to change it to this chapter. This chapter would deprive the applicant of a reasonable use of his land. That's not the standard. A deprecation of the reasonable use of the land is not the standard for the granting of a variance. The standard for the granting of a variance is, would those special conditions, which were listed, impose an unnecessary hardship, which is created by the literal enforcement of the provisions of this chapter. So we've struck in the provision which lessens the standard and reinserted the standard that the statute requires. Beginning on line 173, 174 rather, I've added all of these new sections. In considering a variance as applied to a structure, the board may, in addition to other relevant considerations, consider the following grounds to determine whether an unnecessary hardship would result from a compliance with the ordinance. And then there are 4 other grounds which can be considered. This has been added because the statute was amended by the Texas legislature last legislative session and specifically added this into the statute as additional considerations that can be considered by the board. So this is language taken from the statute and put directly into our ordinance.
Is 50% a requirement then by that statute?
Yes, it is. All of this is language which is directly lifted from the statute and put here. Not a word was changed.
Well, you don't have to prove these, though. These are just specific items.
These are other considerations that the board can take into consideration when deciding whether or not to grant a variance. To make it clear, I personally don't know why the legislature added it. I wasn't around for the public hearings, didn't pay attention to the public hearings. All I know is now it's in the statute, and so we're going to put it in our ordinance.
It seems arbitrary to say 50% whenever it could be or not be considered anyway. It just seems odd.
50% of the things the legislature does to me seems arbitrary, but you know.
Oh, well, then that explains it.
So the next
What's
section.
also weird is the appraised value of the structure.
Yes.
The structure. So I feel like variances come in when someone's trying to build something new. I guess they're referring to the current structure that would be on there, which
Right.
may be a derelict old building. But if it's from the state code, then it's from the state code, correct?
Yeah, I haven't done a dive into these to see, in what situations they would be applicable. I just know that it's now in the statute and we should put it in our ordinance.
Okay.
Section 180, line 187, 107-493, appeals. I just included the language based on error, which is consistent with the statute. And A through all of my changes that I made here, I just took the language from Texas Local Government Code 211.010, which is the provision of the Texas Local Government Code that talks about appeals to the board based on an error made by the building official or the zoning official. And this language is just right out of the statute so that it's consistent with the statute. I struck section 107-494, and that's because it's now included in the above section, in section number, let's see. Where is that? 228. Oh, it's in section D above. An appeal stays all proceedings in furtherance of the action that is appealed unless the official from whom the appeal is taken certifies in writing to the board facts supporting the official's opinion that a stay would cause imminent peril to life or property. That's right out of the statute, and so that's now in section D. So I've struck it. I've struck section 107-494. Line 237 and 238, I included a catch-all provision this is the notice of the hearing part that someone asked about earlier. This deals with all notice requirements. So I included this catch-all language that says, or action authorized under this chapter. So now, not only does this apply to a hearing on an appeal, request for a variance, or application for a special exception, it also applies to any other action authorized under this chapter. Of course, one of which isn't listed here, is in cases of uncertainty determining the appropriate zoning district for a use. All right. And I did it as a broad catch-all in case the board is given other functions later down the road. We don't have to worry about also changing this notice section. Other than that, the notice provisions remain the same.
Hey, Charlie.
Yes,
Are
yes,
these
sir.
notice provisions? They're not structured by the state, correct? These are our city.
That
notice
is correct.
provisions?
These are ours, with one exception. No, that's right. Yeah, these are ours. The state actually doesn't give any requirements for notice provisions. So these are our
Okay.
own notice provisions.
This is a minor point, but we talk about in the section. Where did it go? Just read something about 200 feet. Oh, line 204. You're allowed to appeal if you're within 200 feet of the property, but notice goes out to 250 feet, which is just sort of weird and doesn't align.
Yeah, the notice provision is your decision. The 200 feet decision, a person who can aggrieve is right out of the statute. So.
Can we require they put a sign in the property?
Are you allowed to increase that? Go ahead, Mike.
It is, yeah. I mean, you mean, are we allowed to say? Can we? So ask the question again.
I think Jordan was asking if we can change the radius.
So who has authority to appeal?
I think for purpose of notice.
Oh, notice, yeah. Because the statute doesn't spell out specific notice requirements, I think you're pretty free to establish the notice requirements that you'd like to provide for.
And Charlie, just for clarity, could the board change who could file from 200 to?
No, I don't think you could do that. Yeah, because that wouldn't be consistent with the statute if we changed it. It would be more or less. Yeah.
I think it would be nice to see.
Well,
Sorry, Jordan, go ahead.
no, Mike, you were about to say what I was going to say. Go ahead.
I think it'd be nice to have signs in yards for notice.
Oh.
Okay.
Yeah, I agree.
Or do we have all right.
Could you
y'all
go
wanna
into a
discuss
little
that?
more in that when you say signs in yards?
Well, like City of Austin, when you request a variance, they put a big green or yellow sign in your yard and it says variance. It's got the case number, it's got the date for the hearing. And so, if you live 300 feet away, but you don't have the same rights, but at least you want to come and have your voice heard. You may not get noticed, you may not know, but you drive by every day and you see the sign. So I think it's the most effective notice tool almost.
Doesn't matter to me. I just need direction on what I need to draft. There's going to be
makes sense.
expense
I like an
associated with it to the
addition of
It's
city.
super easy,
Right.
it doesn't cost anything.
Old school.
Well, it's going to cost the city. The city's going to have to print up the signs and everything and have them available. So there's some cost. I don't know how much it is.
What do you think, Carrie? Do you want signs or no signs?
These don't happen that often.
I am agnostic.
I mean, how many of these do we get?
There's only a few of these a year, aren't there?
Yeah, there's only a few a year. The cost is probably less than $300 annually.
Can we have the applicant pay for it? Or the,
I think probably the
It could be included as part of the filing fee. Yeah, it could be recouped for sure. Hmm?
The city of Austin has a sign they use, a Sharpie.
Yeah.
They just have a
Mhm.
pre-printed thing and they just Sharpie on it.
That's
You
pretty-
could order, you could order
Silver
20 of
signs.
them and last
pretty-
a decade.
For
Pretty common.
shopper.
Pretty common. A lot of cities do that. Mhm.
So, why don't we keep going through all the other changes, and then if y'all wanna
Okay.
make
Well-
a motion, let's get through the rest.
Who is supposed to do this mailing here?
The city,
The city.
the city has to do it. I have to do it.
Why is that?
I have to do it because there's certain statutory requirements, and so I need to know precisely what date and how long the notice was. I can't trust the applicants in this case to do that for us. You know, you're aware, we have the notices that go out ahead of building.
For a building
But
permit?
that's just our local requirement. There's no legality related to that because this is quasi judicial. It needs to be essentially the same notice each time with the same.
Is
at
there
a
any
time.
okay, but
But
is there any
the
reason
cost of
why
which
that
can-
the applicant shouldn't be responsible to mail these things out?
To pay for them or to mail them?
To mail them. I mean, the way
Well, I
that it
think- well, I
works, the
think
way
they're-
that, the way that it works with the building permit is that the city provides the applicant with the names and addresses of the people that should be notified. And then it's the applicant then typically mails a letter and typically mails a certified letter to all of the people on that list. And then there is some checking that goes on at the end and say, well, did you do it? Yes, we did it, and so on. And then the process goes on. Is there any reason why the city should be burdened with this piece of work?
I'll let Charlie weigh in if he wishes, but I think because we're stating that X people within so far have to be noticed ahead of these hearings. I need a record if that ever comes up.
My preference is if we're going to have a hearing, a notice requirement, for that the city handle that notice requirement to ensure that it's met.
Mhm.
I could see multiple difficulties with having the applicant do it.
There's also only a few of these a year versus however many building permits there are in a year.
Mhm.
It's a good reason not to change the radius though.
The one thing that I will say as far as the 250-foot radius is I do like the consistency that we just tend to say 250 feet for everything, regardless. It makes
So the
sense.
sign helps with that.
Mm-hmm. If you all would like to add a sign to this, I'm completely in favor of it. I think that's we have people put signs for their construction in the yard, so I think this would be completely appropriate. And if you want to add it,
Is anybody taking notes on the comments for possible changes
I
so
think
that
that's
we?
the first one.
I've got a
Okay.
note.
Because if we do have motions later, that include some changes, I want to make sure we have that all on a list somewhere.
And maybe the sign, if we do that, could be whatever the same notice period is for the mailers, so it's just the same process. Who does the mail and the sign at the same time?
Okay. Continue.
Section 107-496, Section A, has been moved to Section 107-493. Let me make sure that we did that. Yes. At the hearing, any party may appear in person or by agent of the attorney. All testimony shall be given in a manner prescribed by the rules of the board. Board may administer oaths, compel attendance of witnesses, and require production of documents under such rules as the board may establish. That's all in the statute, and is not really necessary to be in the code, in our local code. I can include it if you want, but it's not necessary. And then there's a section in here that talks about.
Those are lines 252 to 255.
Yeah, I think
Yes,
he's
yes,
talking about
yeah.
what was removed.
And I just noticed something that we need to change. So can we go to line 222? It states, and this is out of the statute, so this is statutory language. The board shall set a reasonable time for the appeal hearing and shall give public notice of the hearing as provided, oh, I did say it, okay, and shall give public notice of the hearing as provided in this division, and in
Should it be in
addition,
this chapter?
it should be this chapter, yeah.
You had division elsewhere, but I think you intended it elsewhere, is
Yeah,
that right?
I probably, oh, no, this should be,
This is
this
division?
should be division, because
Yeah.
it's, the notice, the hearing notice requirements are in this division, so that should be division. I did get it right. Whew. In addition, give due notice to the parties in interest, and that's right out of the statute, so I left that language in.
In parties and interest is a defined term,
No,
or
it's
what?
not a defined term, it's a term of art used by the statute. I honestly believe that when we're giving notice to people within 250 feet, and in certain instances to the entire city, I think we've got ourselves covered with respect to that issue. We could actually, in my opinion, strike, and in addition, give due notice to the parties in interest. The problem, I think, in striking that is that there could be parties who are not that don't have ownership in town, that wouldn't and don't reside within the city limits, or don't aren't within 250 feet, who might be an interested party and be entitled to notice. So I think
How would they be entitled to notice?
a trust is a good example.
But if they're not within 250 feet?
Right, but they may be a party in interest. Another would be a commercial property owner I think I'd rather leave it in there. Okay, and then the next, on page 224, it says, a party may appear at the appeal hearing in person or by agent or attorney. So that's from what we struck. In addition, so going back to line 256, it states hearings conducted by the board, I've struck all this. Hearings conducted by the board shall be open to the public. That's state law. We can put it in there if you want, but it's not necessary. All the hearings have to be open to the public. The board may meet in an executive session pursuant to Government Code 551. That's also state law. It doesn't need to be in here. The board shall hear the intervention of any owner or property adjacent to or in the rear of or across the street from a lot with regard to which the grant of appeal, variance, or special condition is pending, and shall also hear from any other parties of interest. Also the law. Anybody who comes to the public hearing has a right to speak, regardless of who they are, where they're from, parties of interest, not a party of interest, just in town visiting and they have an opinion. Everybody has a right to speak at the public hearing. So I just struck this section. It's completely unnecessary. Moving to line 262, I have added the line, with the exception of a decision on an appeal based on an error, which decision shall be determined as provided for in section 107-493. And in 107-493, we talk about when the decision has to be handed down, and that's statutory. The statute tells us when that has to be done. So that has its own separate decision by the board process. However, all other decisions of the board have to be made within 45 days of the hearing related to said decision. And so I'm trying to keep your original 45-day language in here for everything other than where the statute says something different.
So they don't necessarily make a decision on the spot in the meeting?
I've had boards of adjustments
They don't have to, I guess.
adjourn until a separate date and continue the discussion. On line 269 and 270, I added another catch-all. No appeal request for variance nor application for a special exception or other previous application may be filed by the same applicant, et cetera, et cetera. So I just added that catch-all. Finally, all of the additions that I made beginning on line 292 is right out of the statute. And so I just deleted what was there and replaced it with what the statute says. And that's all. Sorry it took so long, but there were quite a few changes.
I think earlier we got off topic, but you had said there was a section that kind of was a little bit problematic for you, and I don't think we wound up talking about it. It was somewhere in.
Oh, that's
this
right.
page
There was
six.
one sentence. There was two things where I wanted to make
I
a
think it was like in the
comment.
130s.
Yeah. Two places where I wanted to make a comment, actually. And I will find it. Oh, it's in the variances section. Page 137.
Page or
Line.
line?
Line, I'm sorry, my apologies. Line 137. And this is a variance, the granting of a variance in a commercial district, right? Or district other than residential district. Granting the variance will not confer on the applicant any special privilege that is denied by this chapter to other land, buildings, or structures in the same district. That's exactly what a variance does. Every variance that is granted grants a special privilege to that piece of property that is not enjoyed by any other piece of property. We need a variance to our setback requirement. If setbacks is 10 feet, we need a variance to do X. Well, if you grant the variance, guess what? You allowed them to build into the setback, and that's not a right granted by anybody else in that section.
Well, is it sort of being interpreted, or is it presumed that there's already been the hardship finding, which would not necessarily be a finding for a similar landowner in order to grant this variance? I mean, is that something that's just
I don't know.
presumptive?
I really don't know. When I read this, I read it to say that if you grant them a variance, it can't give them any special privilege that's denied to other land, building, or structures. And that is the very nature of a variance does.
I thought what it's trying to say is that if you give the variance to this property owner, and I don't know what an example this would be, it can't automatically also give that variance to another property owner at the same time.
Yeah, they couldn't do that under the law anyway, because you could only grant a variance
That's
to the
kind of how I
specific
read it. I
property.
think it's poorly written, but
Yeah, I didn't read it that way, but I guess my question would just be, is there other language that presumptively would apply having to do with the granting based on the unnecessary hardship? And so, therefore, I read it just to say, you still have to meet the findings of hardship. You can't just say, oh, we really like Joe here, and so we want to help him out. There has to be something else involved.
Well, let's break it down. Granting the variance, so if you grant the variance, it will not confer on the applicant, the person who is requesting the variance, any special privilege that is denied by this chapter, the zoning chapter, because that's what this is applicable to, is the zoning chapter, to other land, buildings, or structures in this same district. So,
yeah, I thought the sentence was in the
That
wrong
just
order.
says
It was
that-
basically
Yeah, this variance is only a one-time thing.
Mm-hmm.
That if the person who is if the applicant has more than one property and gets the variance for a specific piece, one of those pieces of property, that variance doesn't apply to any other piece of property, just the one that's being applied for here. Yeah, it's unique.
okay. Well,
So you think it says structures are owned by the same applicant?
Well, that's what does not confer on the applicant any special that is denied by this I would imagine that the applicant is gonna be, if he has more than one property to represent, whether he's the owner or just a manager or something like that, that what this says is whatever we're talking about here is only about one piece of property, nothing else.
Yeah, I don't think it says that, but.
Yeah, I don't either.
That, I guess,
I think it was just
it's
poorly drafted and no
ambiguous if
thought was
we're all
put into it.
interpreting it in a different manner.
Well, I was thinking it was that if you added words such as after other, and you said similarly situated or something like that, so that if you have a row of properties along a creek that need a setback that have a similar situation, but you're not going to allow one person that has a situation that may not be so unique end up with some benefit that is different than the surrounding properties or anything else in the area. I don't know.
What about, Charlie,
Yeah, I think
if
you're-
we
yeah,
added a line, if we said granting the variance, comma, consistent with the other provisions of this ordinance, comma, will not confer. That way, it's clear you have to meet all the other requirements.
Well, it's
And
clear.
it's not that, you can't just come in and ask for favoritism or
Well,
something like
I
that.
think it says that.
We did that I'm proposing that we do that at the beginning of this, section B where this all starts.
Yeah.
B
You're
says,
thinking you could just strike that.
I'm thinking you should, my opinion is, from a
Just-
legal perspective, that
just
this should
strike
probably
the whole-
should be completely struck.
Well, I'm fine with that too, as long as we.
Yeah, I think it's trying
Yeah.
to. I think maybe it's trying to say this can't be applicable anywhere else, but I think it's written wrong.
But that's
I think it's
not
written
what
wrong.
it's not.
Yeah,
what it's
I
saying.
read it to be an anti-favoritism clause.
And that's
Yeah.
not what, and you can't do that in the law, under the law anyway. They couldn't
Right.
grant a variance to this applicant and some other piece of property that they happen to own that's not in front of them, or to any other person.
And you feel comfortable that other provisions take care of it?
Yes, I do.
Okay,
Yeah, I think so too.
we'll take it out.
Okay, I made a little note too. And then there was one other thing, I apologize, I meant to mention it while we were on it, and then we got sidetracked a little bit, so let me see if I can find it real quick.
Thank you, Tony, for remembering.
Yeah,
Said
thank you
that.
very much.
I earned my money tonight.
Oh. This really isn't probably that big of a deal, but if we look at section 107-4, now the new section 494, line 250, when we're talking about who notice has to be provided to, section 4 says all other persons deemed by the board to be affected thereby. That's a little odd to me because typically the board isn't going to meet prior to the hearing to make the determination. So this seems to imply that, this could create problems from the standpoint of timing, notice, and all of those things. Because if we get to the meeting and the board says, well, we think you should have given notice to these other folks. So the question is, when we get an application, should we have a meeting, make all the board come in and say, okay, who else should get notice? Right, and so, maybe we either
But it's
strike
not
this.
statutory, you
Yeah, it's
strike
not statutory, or maybe either strike it, which would work, or to say all other persons deemed by staff or the city administrator or somebody like that, who can make that determination based on the application before them. Those are my two. You don't want to do that, staff?
What staff?
For
would
the record,
recommend-
staff does not want to
Okay,
make those
yeah.
decisions.
So, we may want to strike this section because it does add a complicated
Take
factor
it
to it.
out.
Yeah.
If it's not needed.
I think if you strike that and then add signs to the yard,
Yeah. So add signs.
it would,
It's in
And
there.
are
There you
we,
go.
do we have consensus that we want to add signs? to
Yeah,
the-
that's actually
I
probably
like
a good
that
place
idea.
to put
Sign
it.
is fine,
Yeah.
it's only a couple and the cost can be passed on.
Well,
Yeah, we can
do
pass
like
this
the
cost
city
on
where
through the
we could
fee.
just do blank signs, play with Sharpie.
And I'm sure there's some boilerplate language out there that we can utilize that will,
Probably just copy the Austin,
yep.
Yeah.
Take a picture next time I see one.
Many cities utilize signs for not only variances, but for zoning changes and things of that nature.
Well, doesn't Westlake Hills do it too? I mean,
I don't
think
know if
they
they
do.
do or
I've
not.
seen
It wouldn't surprise me if they do.
the
Mhm.
Westlake side that did it.
That's all I have.
Thank you, Charlie.
Do we have any, I mean, are we comfortable with the sign, with the change? First, are we comfortable with that, with what I brought forward with respect to the changes with respect to state law and clarity? Okay.
Yes.
Absolutely.
Want to add the signs provision,
Mhm.
and strike the notice as required by the board provision?
Mhm.
And there was one other change that we discussed.
The-
Deleting lines 137 through 139, which the
Yeah.
conferring a special benefit.
Right.
Can we get a motion to that effect and to make those recommendations to city council?
Would someone like to make that motion?
Do we need to specifically say where we wanna add sign, language regarding the sign? Or,
No, we're gonna put it in the notice provisions. I'm comfortable knowing where you wanna put it. If you guys are comfortable with that, I will actually make the changes and take it to council with those changes in them already, so we can move this forward, if everybody's comfortable with that.
I'm fine with that.
Okay.
Do we have anybody who would like to make that motion?
I'll make a motion. I'll make a motion to approve the language as presented with the following changes. To strike section 107-492 B4, which is also lines 137 to 139. To also strike section 107 dash, what is it, 494,
Yes.
little b, number 4, which is also line 250. And also to add a requirement for a sign in the notices with the same, notice period as the required mailers from the city.
Perfect. I'm good with that.
All right, do we have a
I'll
second?
second.
All right,
Ca-
We good?
I have one point of discussion before we vote, if that's all right.
Yeah, sure, it's fine with me.
Charlie, is this gonna cause, is this 30-day notice going to cause, I'm less concerned with the mailers than the sign. Is it gonna cause us a problem, with the time clock?
I don't think so.
Okay,
Signs can get up faster than the mailers.
well,
Right, as soon as
but-
somebody comes in with an application, as soon as we determine when the hearing is gonna be, right?
right.
How would
The,
that be a
the
problem?
30 days that is not, doesn't have any bearing on the 45-day time clock for
I don't think
review.
so.
Okay.
Let me look, let me just
I don't,
verify.
I don't think so, but I
City
wanna
of
make
Austin
sure.
puts their signs up either 10 or 14 days in advance of a hearing. I think they sign it differently than they mail,
Okay,
but
Yeah, I guess whatever's easier. I was thinking maybe you're doing the mailers, you do the signs.
Do the
same
sign.
I
time.
mean, if it's easier for
I-
you, we can make the signage notice like if it meets the law 10 or 14 days before the hearing, because I think that's plenty.
Yeah, no,
I
that's
mean, you don't need a sign for 30 days.
15 days,
Sure.
14 days?
I think 15, I'm good with 15.
Okay. So with that change?
Okay.
Everybody okay?
all right. All right, and you're okay with that amendment?
Yes.
Yeah, okay. All right, do we have any further discussion about the changes to this ordinance before we vote? If not, all in favor of approving the amended ordinance with the changes in the motion, please say aye.
Aye.
Anyone opposed? Any abstentions? Motion carries. All right, let's
Thank
move
y'all very
on.
much.
Thank you, Charlie, for your good work. All right, I believe the last thing we have on the agenda tonight is the hybrid meetings policy.
We have a public, do we still have a
Oh,
public
yeah,
hearing?
there's a public
Oh,
hearing.
yes.
Number 7.
Where's my agenda?
And we posted that as a public hearing on the comp plan. Since then, the council has kind of gone a different direction. They're first going to do a series of workshops
Oh, so
on
we're
the
not gonna do
comprehensive
this.
plan.
Okay.
They want to break it down a few chapters at a time and just have workshops where the community can come and one more time review it, give some more input, and the council will also do that. At that point, it will come back for the official, once the plan is finalized and we get more towards that comprehensive plan as in the local government code, then we'll come back for that public hearing and
Okay,
run
I
it
didn't
back
see
through.
public hearing in the agenda, but
Right.
I thought this was more of an informative
yes.
presentation.
Yes, and we'll maybe bring it back even for that final presentation after this next round of workshops. It's going to be a few months while they, work through all of the
So
final
we're not
input.
gonna get informed on it tonight.
Correct.
In fact, that we're gonna wait till it's in a more final form.
Yes,
So,
Okay.
absolutely.
Just for my education, so what would be the expectation as far as that being a topic here for this commission to do? What would we do with that?
With the actual plan,
Yeah.
Going
just
it
if we say
forward.
we like it, we don't like it, we think we ought to do this, what is it supposed to happen?
absolutely open for input from the commission. In the end, kind of the things that are adopted in that plan, a lot of them are going to be being carried out by the Planning and Zoning Commission, or y'all will have a hand in that. Changes to the ordinances that are going to come later that follow the plan. So I think it's just still very much in the public input and, council looking at phase and the different boards and commissions getting their eyes on it one more time. So I don't think we're quite there yet.
So it's coming to us for input as opposed to approval or.
Mm-hmm.
Right.
I think we don't
Under
have,
the law, you have to hold a public hearing on it.
yeah, I think we
When
just
it
have
comes.
to have a hearing, but our input is, I don't say it's meaningless, but council can, choose to take it or not. I think it's how that works,
Mhm.
right?
For that final public hearing, that one is just kind of a statutory requirement. But they do want everyone's buy-in since it's going to be a whole community effort to get that plan.
Well, let me ask this then. Having gone through it, are there expectations from this commission with regard to execution of that?
Carrie, do you want to grab this? I would say at this time it's really more the big picture ideas, but once it's a fully formed plan.
Yeah, I think based on these workshops the city council has, what may come as a result of that is they may take pieces of it and send it specific pieces to you all to make zoning changes. So if there's a piece of the comprehensive plan that relates to the commercial zoning district and setbacks, they may send that back to you all specifically to say, we want planning and zoning to look at this recommendation of the comprehensive plan and review our current setback requirements and consider updating that to be in alignment with the comprehensive plan. That's, I think, the kind of the longer vision for what will come out of this is they'll have workshops that will generate the discussion of which pieces need to come back and be revised in our current code.
I had a discussion here recently with one of the authors of the plan and had asked that person, did they think that there was any rule in there for planning and zoning? Oh, absolutely, was the answer. I said, well, what is that? Well, one of the main things that we want to have happen is application to the state for funding for getting some of these things done. That should be done by planning and zoning. Is that right?
I didn't hear, I was reading the statute just so I could
I-
make clear, just so y'all know what your obligation
I don't know the answer.
Okay.
I will say that if that is a component of it, then we have to have the comprehensive plan has to meet certain requirements that in the state that it's in right now, it does not meet for those purposes.
What was the question?
If part of the purpose of this comprehensive plan is state funding, state grant related.
Is
With
it part of the
planning and
purpose
zoning
or part of the purpose that planning and zoning consider it?
Well, the statute says a comprehensive plan may be adopted or amended by ordinance following a hearing at which the public is given the opportunity to give testimony and present written evidence, and review by the municipality's planning commission or department if one exists. Well, a planning commission exists, and so your role will be to review the comprehensive plan.
So,
That's your statutory role.
Charlie, correct me. I believe that there occasionally is grant money available for cities for certain projects if they have an adopted comprehensive
I
plan.
am
Is
not
that correct?
familiar with the grants
Okay.
and what their requirements are.
That may need
Okay.
to be an offline discussion.
Yeah,
Just,
we'll look further
Yeah.
into
just
that
trying
to
to feel
see
my
if
way
that's.
around in this job.
Yeah, there, I mean, there may be, I'm not saying that those types of grants don't exist that require a comprehensive plan, but I can tell you that in my 20-some years in doing this, I've never ran up against a grant that required you to have a comprehensive plan. But that doesn't mean they don't exist. I don't know all the
Well, there may be
grants out there.
somebody out there who's
Yeah.
an expert on that subject that.
Well, there's just so many
Wonder
different
who that
grants. Are
is.
you talking about
Yeah.
federal grants? Are you talking about state grants? Are you, I mean,
Right.
and what are they for? You know,
Right.
there's grants for all sorts of different things.
Okay, well, thank you, Carrie. Unless we have anything further, I'm going to adjourn this meeting at
Wait,
7:30.
we need to update the hybrid meeting.
One more
Hybrid meeting.
Oh, I thought,
Sorry, one last one.
let me. Okay, right, update and discussion.
Yes, just wanted to let you all know, and this is actually a perfect example of it because we have Jordan Scott joining us virtually for, I think this is our first actual official hybrid meeting we've had in the city, where it's a true hybrid meeting in that there's an actual board member or council member present, virtually. This policy that you'll see in the packet, feel free to review it. It's already been approved by city council, and I wanted to let you all know about the requirements. The only kind of catch to the whole plan and all of the hybrid meeting things we're doing is that it does not fulfill a quorum requirement to have someone present virtually. So if they're here virtually, that's great. They're able to participate. They do not count towards quorum, and also the presiding officer has to be physically present. So at all times, we would need 4 members here, one of which was the presiding officer, and then other members could be in attendance virtually. So the policy kind of outlines how we would prefer that kind of notice. If something comes up last minute and we can accommodate it, we'll absolutely, accommodate those kind of virtual attendance. We just didn't want everybody at once on the day of trying to get virtual and then us not be able to make a quorum.
And let's double check whether or not we can do it at the last minute. Isn't there special notice requirements under the statute if you're going to have a hybrid meeting?
We have been noticing them all as hybrid option.
Okay.
So we've been putting we put it in the agenda language right up top that members of the commission can be present virtually as long as a quorum is present.
Okay, all right.
So I
Okay.
think we've pretty much covered it both ways. They may
Okay.
not all end up being
Very
hybrid
good.
meetings.
But when a vote is taken, that person who is online, that affirmative or negative is recorded, right?
Yes.
Even
Yes.
though they're maybe not part of the quorum.
Yes, they get to vote and participate in the meeting for all other purposes. The other problem that kind of creates, if we were to lose audio and video feed and there is a board member joining from home, even though they don't count towards quorum here, the meeting would have to be recessed until we could get audio and video feed back up. That doesn't apply if there's only members of the public watching from home, but if we do have somebody participating in the meeting that way, we would have to adjourn until we could get our systems back together. So we hope that doesn't happen, but of course technology sometimes
And
doesn't
that's even
cooperate.
if they're not a part of the quorum. I
Yeah.
mean, it's just,
Right.
So if Jordan goes out, we gotta stop.
Right.
Yeah, if both audio and video feed are lost so that the public can't hear or see the proceedings, if we have a remote board participant, then the meeting has to be recessed until such time that it is resolved. And if we can't resolve it within 6 hours,
I think.
then the meeting has to be adjourned.
Yes.
It's a lot of pressure.
I think if we get to 30 minutes, we just say we can't.
Yeah. I think
Simple
we'd-
salute. The IT department's closed.
Go home and
Yes.
take a nap.
I agree with that, and now I agree with that
yes.
to the extent my
Jordan, I'd like to point out that item C, perhaps you didn't completely comply with this meeting, but we're gonna give you a free
Well,
pass.
I was obviously laboring under a misconception at the beginning of the meeting. So,
If you're responsible for a 6-hour delay, you're automatically the
Chair.
The chair.
Chair for each hour of delay.
I like that chair for life and you're not allowed.
1
to.
year per hour.
All right.
That works for me.
But yep, if y'all have any questions about the policy, feel free to reach out to me and we can discuss them further.
Okay,
Cool.
now we
Great.
really don't have anything else on the
We
agenda.
really don't.
Correct, we really don't. So I'm adjourning the meeting at 7:17.
Thanks, Amy.
Thank you.
Thank you all.
Exceptional job.
Well done.
surely.